Were you lying then or are you lying now? Which one is the lie? Oh, I was lying then. So you're a liar. So why should we trust you now? 20 years to life on perjury. That's how serious it is. What they're gonna do is they are gonna try first to weasel their way out of it. They're very good at it. They are master manipulators and master deceivers.
That may save them from life imprisonment. You hear that, the McAlberts?
Well, hello everybody, and welcome back to Buckle Up, It's the Law. Folks, today we're going to be talking about one of my favorite questions that I have ever received in my entire career as a professional. I get this question more than I get the question of, can I represent myself in court, or how do I remove a judge? Both videos which I have covered on this channel. Either it's going to premiere or it's already on my channel, so go check those out in case you're interested. And that question is
that perjury? Isn't that perjury? That person just lied on the witness stand. Shouldn't they be charged with perjury?
That is a very fascinating legal question, because you understand you can't on the street, let's say for example your friend says, hey, can I borrow $5? I'll pay you back tomorrow. And you give them $5 and you come back the next day and say, hey, can I have my $5 back? And they say, no, I spent it. I don't plan on ever giving it back to you. Screw you, I'm going home. And you're like, okay, Cartman, that's perjury. You just perjured yourself. Did they though? Let me tell you that you probably already know the answer. They did not, of course. Perjury is a legal definition. They lied to you. Absolutely. They said they're going to give you the $5 back the next day, but they didn't give it back. They lied to you. But when you do it on the witness stand, sometimes, not always, sometimes that is called perjury. So let's explore the topic a little bit. What is perjury? What is the legal definition of perjury? What does it mean to perjure yourself? And is it actionable? Allow me to say right out of the gate that perjury absolutely is actionable, both criminally and civilly. The difficulty that most people have in getting someone, like for instance a police officer that said one thing on the report and then a totally different thing on the witness stand, is you will never be able to find a prosecutor who would be willing to prosecute that individual for perjury. There is a clear double standard. So when you, the citizenry, the civilians, the non-law enforcement agents, commit perjury, an actual perjury, you get charged. There is a double standard. You get charged while the police officers don't. So that begs the question, what is the definition of perjury? Perjury is when you have two statements, both made under oath. It does not have to be physically sitting in the witness stand. Sometimes you give testimony under oath in a grand jury proceeding. Sometimes you make statements in a suppression hearing. Sometimes you may just be in a deposition with a court reporter in the room and everything being recorded. As long as you have one statement where you said, John was wearing a white sweatshirt and he never went into the house, and later it gets discovered that John was actually wearing a green sweatshirt, and you testify to that, and you say, oh, yeah, John was wearing a green sweatshirt and he did go into the house. Well, now you have two inconsistent, contradictory statements. As long as they're about a material fact, if you just maybe got the color wrong from navy blue to sky blue, I mean, those inconsistencies are not so inherent to be enough to call it perjury. But John going in the house and John not going into the house is a material fact, and if you testify at some point that John never went into the house and then he did go into the house and both of those were made under oath, then one of those statements, you are lying, sir or madam, right? So how does one get charged with perjury? Now, let's say we do have a prior inconsistent statement where John went into the house, and today you are testifying and you're saying, oh yes, John went into the house, as a matter of fact. I'd like to change my testimony. You may even go so far as to say, I'm aware I'm changing it. I want to change it. So one of my favorite questions that I would ask someone in that position, and this is called impeaching the witness, something that we're going to see very much in trial number 2, and that is, so sir or madam, were you lying then or are you lying lying now? Which one is the lie? Oh, I was lying then. So you're a liar. You're admitting that you lied previously under oath. Yes. So why should we trust you now? You see how quickly they get eroded. Your trust in them as a juror is eroded. You may not trust anything else that they say because perjury is a very serious crime. Now, once again, I said that police officers lie all the time and they perjure themselves all the time. I don't think I have ever seen a police officer prosecuted for perjury. All I have seen is they either get transferred to another department, best case scenario, or worst case scenario, they either leave or get fired and are no longer a law enforcement officer for the rest of their lives. So that's the problem. That's the problem with perjury. But when you, Joe Citizen, takes the stand and testifies and does the same thing, well, the prosecutor may levy charges against you. They may use that to strong arm you to plead guilty in the other case so you don't waste any more of their time. They now may find an avenue of getting you to do something you don't want to do because now you could be criminally and civilly prosecuted depending on the circumstance. So let's talk about the Karen Reed case. In the Karen Reed case in Massachusetts, we have a lot of police officers, a lot of law enforcement agents, and citizens, connected citizens, mind you, who are very connected to the police force. So they're kind of almost hybrid law enforcement capacities, the way that they're acting. Because, Albert is a former law enforcement officer, Brian Albert, and several others. So they're very, very connected. And even though they may not be law enforcement today, they were law enforcement then, and they all are protecting each other. And neither Lally nor Brennan will ever go after them for perjury. But you could find a prosecutor who would be willing to levy charges if, and only if, and this we're going to see happening a lot in trial number 2. So be on the lookout for this one, folks, because this is going to be huge. Perjury could rear its ugly head and attack the Alberts, the McCabe's, Brian Higgins, all the other witnesses that have testified in the Karen Reed case number 1. When they take the stand in case number 2, if they make an inconsistent statement, they could be charged criminally with perjury. So what is the definition of perjury? In Massachusetts, perjury is found in the General Laws, Part 4, Title 1, Chapter 268, Section 1. And it is defined as follows. Perjury: whoever being lawfully required to depose the truth in a judicial proceeding, there it is, right out of the gate, it's got to be a judicial proceeding, or in a proceeding in the course of justice, willfully swears or affirms falsely in a matter material to the issue or point in question, or whoever being required by law to take an oath or affirmation, willfully swears or affirms falsely in a matter relative to which under oath or affirmation is required, shall be guilty of perjury. There it is. If you lie under oath, you can be charged with perjury. Whoever commits perjury on the trial of an indictment from a capital crime shall be punished by imprisonment in the state prison for life or for any term of years. And whoever commits perjury in any other case shall be punishment by imprisonment in the state prison for not more than 20 years. 20 years to life on perjury. That's how serious it is. In any other case shall be punished by imprisonment in the state prison for not more than 20 years, or by a fine of not more than $1,000, or by imprisonment in jail for not more than 2 1.5 years, or by both imprisonment and a fine. Now, here's what I've been talking about. You have to get caught first. So how do you get caught? An indictment or complaint for violation of this section alleging that in any proceeding before or ancillary to any court or grand jury proceeding, there it is, there's that language, relating to an indictment or a complaint for the commission of a violent crime, as defined in section 121 of chapter 140, the defendant under oath has knowingly, that's the standard. They knew what they were doing. It's not an, oops, I'm sorry, I misspoke. Knowingly made 2 or more declarations which are inconsistent. Agree that one of them is necessarily false, like going into the house and not going into the house. You can't happen at the same time. Need not specify which declaration is false if each declaration was material to the point in question, and 2, each declaration was made within the period of the statute of limitations for the offense charged under this section. And the statute of limitation for felonies, infinite, and misdemeanors is usually 1 year. In the Karen Reed case, it would be felonies because they are testifying in a court of law. In any prosecution under this section for perjury, the falsity of a declaration set forth in the indictment or complaint shall be established as sufficient for conviction by proof that the defendant, while under oath, made irreconcilably contradictory declarations material to the point in question. See, like I said, it has to be material. Navy blue, sky blue distinction, even right here, Massachusetts does not take that into consideration. If in the same continuous court or grand jury proceeding in which the declaration was made, the person making the declaration admits that such declaration is false, such admission shall bar prosecution under this section if, at the time that the admission is made, the declaration has not substantially affected the proceeding. So if they come forth and confess, the state lets them go. Or it has not become manifest that such falsity has been or will be exposed. So if you're on the verge of being exposed and you confess, not gonna help you either. You have to be like, look, I wanna come clean, I wanna say this, I wanna tell you I lied. That may save you from life imprisonment. You hear that, the McAlberts? It shall be a defense to an indictment or complaint made pursuant to this section that the defendant, at the time he made each declaration, or she, believed each such declaration to be true or its falsity was the result of good faith, mistake, or error. It's a viable defense if you're like, I legitimately made a mistake. I'm really sorry. I didn't mean to say that. I meant something else. It was misconstrued. You misunderstood, etc., etc., etc. So all of those could be viable defenses to the perjury charge. Now, let me tell you, folks, it is not going to be so hard and fast in the Karen Reed case for two obvious reasons. Number one, even if these witnesses do get caught in the act in perjury, what they're going to do is they are going to try first to weasel their way out of it. They're very good at it. They are master manipulators and master deceivers. So the jury may or may not be able to pick up on it. We pick up on it because we know the story. Jurors may have the wool pulled over their eyes, and this is exactly what the witnesses are counting on. Number two, even if they do get caught and they do get called out for inconsistent statements, they can say, well, I had an honest mistake. I apologize. Allow me to correct my testimony today. They'll try to play it off like it's something innocent, like it's something not serious, like it's something, oh, don't worry about it. I don't know. I didn't mean it. Believe me when I say this, Jackson and Yannetti are not going to let that slide. You can try. I know what you're cooking, but it won't work. Not with a good lawyer. Sorry, not sorry. And third, now we come to the meat. Let's say they do get caught, they don't confess, and now what? Is Lally or Brennan or Morrissey, they're going to file criminal charges against these people, the people that they've been protecting for the last God knows how many years? Not even before Karen came about? Please. Of course, no criminal charges are ever going to be forthcoming. No special prosecutor assigned to this case will ever, to their cases, if they ever have to assign a special prosecutor because of conflicts with the McAlberts, professional conflicts that they can't prosecute them for XYZ reason, which would be barbaric, but I'm sure it exists. If they do bring in a special prosecutor to prosecute them, it's going to be interesting. It's going to be very interesting. The FBI could also step in. It could be a federal prosecution because you tried to cover up a murder. That's a serious crime. So even though Brennan claims that the federal investigation has been concluded, it can always be reopened if new evidence comes to light. So I'm looking forward to all the slip-ups. I'm looking forward to all the mistakes and the inconsistencies and the perjuries, because now we're in perjury territory, folks. Now we're in absolute 100% unequivocal, unquestionable perjury territory. So let's go, everybody. I will see you all in the next one. Bye, everybody.